You did beautifully. You're going to miss me.
That's correct.
Having to say all that.
I'll bring some more trials back if you want.
Y'all come up and visit us. It's been a pleasure to work with y'all, that's for sure. All right, the defendants in the courtroom are ready to resume the trial. I had reserved defendants' request to charge 6, 7, 8, 9 for argument and decision this morning. What says the state?
Your Honor, the state continues to object, given that lesser, for the same reasons as before. This is alleging some violation in a manner not charged in the indictment, thus it would not be a lesser included offense. We are not arguing that this alleged one message sent on the 18th of June is the cause of death or caused him to forget about the child. What we're actually saying is that's evidence that he had not forgotten the child. It in no way reflects in any manner the charges in the indictment. It would be completely inappropriate to give this unrelated, not lesser included offense as a charge.
Further argument from the defense?
No further argument, Your Honor. We believe that it is adjusted to facts and does set forth a lesser included charge as to those counts.
All right. Well, reviewing them, this is not reflective of a lesser included offense. It is arguably an additional uncharged crime. The state has the option of bringing the charges, and they've done so. And it doesn't fit the definition of a lesser included offense, so I'm not going to give defendants request to charge 6, 7, 8, and 9. I note the defendant's exception to the court's ruling. Is there anything further with the state before we have closing arguments, please?
No, Judge.
How about for the defense?
Judge, I would just ask that the state is going to give an opening and closing, that we have a break after their opening for us to arrange a defense. Short break.
Well, what if they give a 10-minute opening? What do you need a break for?
Technology issues that we need to get evidence lined up and whatnot, Your Honor, to make sure make it close smoothly.
I'll do that. I just want to know for sure what we were doing. Yes, sir?
We do need to perfect a record about a couple of charges that we had talked about on Friday that are now being withdrawn. First, the discussion we had Friday at the charge conference, I prepared a proposed charge, emailed it to the defense. They responded that they were not insisting on the charge. It's not required under the law. Thereafter, I sent an email to Your Honor, your staff attorney in the defense, where we agreed that we would be withdrawing specifically state's request to charge 12 and 13. So just make that a part of the record.
Yes, I kept the email that you sent me, and I've removed those from the charge. Anything else to add to that point? Are we ready to send for jurors?
Judge, if I can just have about 2 minutes to set up now that we're done.
Obviously, I'm going to say yes. Go ahead.
Thank you.
Yeah, it won't take long. 3 minutes.
Fine. Come on. Have a good weekend. Did you do anything? Bobby? All Sunday working on the charge. Thank you for checking on me this weekend. I worked on the charge all day Sunday.
That's right.
Thank you. Let's bring the jury, please, gentlemen.
Still you got it, door. You got it okay? All right, okay. That's all right, the jury. Watch your stuff coming in. Please be seated.
Ladies and gentlemen, good morning. I hope you all had a pleasant weekend. The weather was lovely. We are ready to resume the trial of the case. If I take you back to when you were selected and sworn as jurors, I gave you an overview of the steps in the process of the trial. And I told you that once a jury is selected and sworn, then the first phase of the trial is called opening statements. And that was the time when the lawyers addressed you and stated to you what they anticipated the evidence would show. And I told you at that time that what the lawyers say and what I say during the trial of the case is not evidence. We cannot, by what we say, prove or disprove any aspect of the case, but that our law recognizes the importance of advocacy, of letting each side speak to you at the beginning to give you an overview of the case and what they anticipate the evidence would be. And then I told you we would hear evidence. And I explained to you that evidence would come to you either through sworn testimony from the witness stand or from the items that I admitted for your consideration during the trial of the case. And in fact, you've heard and received all the evidence of the case. We concluded the evidence on Friday. So that portion, the testimony and the exhibits, that constitutes the evidence of the case. And it's been presented to you, and it will be delivered to your jury room, the physical items, when you deliberate. We prepared Friday afternoon for the next portion of the trial, and that is the closing argument. And we're ready for closing argument. The things I want to tell you about closing argument are as follows. Closing argument is an opportunity for each side to what we call sum up the case. Sometimes they're called summary arguments. Sometimes they're called closing arguments. But it's their chance to sum up the case. And they can talk to you about the evidence and what they believe are reasonable conclusions to draw from the evidence. And they can talk to you about the law. I spent Friday afternoon going over everything that I'm going to explain to you about the law that applies in this case. And they're thoroughly versed, and they know exactly what I will be telling you when I give you what's called my charge of the law. They know thoroughly what's going to be contained in there, and they are permitted to discuss that with you. And they can talk to you about the evidence in light of the law, and the law in light of the evidence, and argue persuasively toward particular conclusions or interpretations or views of those things, the evidence in light of the law and the law in light of the evidence. And they're permitted to argue persuasively toward a particular verdict by you as to each of the counts of the bill of indictment. Simply remember that what they say is not evidence, and the evidence has come to you from the witness stand and the items submitted for your consideration. And with those instructions, we'll move into closing arguments, and you may proceed.
I love my son-in-law, but we both need escape. I love my son-in-law, but we both
case. Those words were uttered 10 minutes before this defendant with a selfish, abandoned, and malignant heart did exactly that. He drove Cooper to that Home Depot Treehouse parking lot, and his selfish, abandoned, and malignant heart left him there to die. On that morning, June 18th, 2014, he did exactly what he said he was going to do. And on that morning, as he drove into that parking lot, he drove past the parking spot that he eventually went to his right. As he stopped and backed up, in that parking lot, with his son inches away from him, pulled in and sat there for 30 seconds before closing the door on that little boy's life. That morning, he had strapped that child into his car seat, this wide-awake, 22-month-old beautiful child who was excited to go to school and actually said as much, into a car seat that was clearly visible to anyone inside that car. That was clearly visible to anyone inside that car. That was clearly visible to this defendant. He closed the door on Cooper's life and left him to suffer an unimaginable, horrible death that just 5 days before he watched a video about. 5 days before he sees a video on a site, a video that's entitled, "How Hot Does It Get in a Parked Car?" And he watches that video. Video that talks about how terrible it would be. Video showing that even on a day where it's breezy outside, you can see the leaves blowing in the trees. Even on a day where you've got the windows cracked. You can kill a living being in no time at all. 5 days before he closed the door on that child's life, he watched a video showing and instructing how a living being can die in quite short order. And that's a situation we know from the defendant's own words that he contemplated for his son. As he told the police, when he was watching that video 5 days before, the police didn't know how soon it was before this child's death, I watched it and I thought to myself, I would hate for that to happen to my son. And knowing what a horrible death it would be, but also knowing the effectiveness of this method of killing, on June 18, 2014, this defendant chose that death for Cooper. He closed the door on his little life because of his own selfishness, because of what was more important to him. His obsession
and his other life. Now, throughout this trial, we've seen a number of videos. We've seen a number of photographs of Cooper playing with his dad on the beach, playing with his mom, things like that. And I'm sure we'll probably see some from the defense's closing argument. We're going to show pictures of a wide-awake, verbal, I'll point out, Cooper, a vivacious, beautiful little child. But he also saw that in this case, in the weeks that they returned from that Memorial Day weekend vacation, a vacation the defendant did not want to take Cooper on, after they got back, I know we saw one photo of Cooper a week beforehand sleeping in daycare. Out of all those videos, all those photographs, we know the defendant had been unhappy at work. We know in the months leading up to this that his wife had actually complained about him going out and that her priority was Cooper. And you're going to hear that a day, we've already heard, that a day after they had this discussion via text, he has gone on the Home Depot website and has gone to a page regarding divorce separation checklist. And a couple of days after that, he doesn't get the job at Chick-fil-A. Over this time and after that time and after the trip to Memorial Day to the beach, the evidence showed the defendant's behavior was escalating. In addition to being unhappy with his job, we know that in that time the number of photos the defendant took or sent out or received regarding his other life, regarding the life he wanted to live, far outnumbered anything or any involvement with his son Cooper. We know that in these weeks after that vacation, leading up to June 18, 2014, at a time that his wife was asking him to come home and spend some time with her and Cooper because they were going to be leaving a few days later, he lied to her about what he was doing, and he went to a seedy Marietta hotel and had sex for money with a prostitute. That shows you the behavior and how his priorities were set and how this was escalating leading up to June 18, 2014. We know that during this time, the defendant's behavior was escalating. That after that vacation, he in fact was messaging with what turned out to be a 15-year-old girl. Something we didn't find out about until after indictment. And when he found out she was 15 years old and had sent a picture of her vagina, what did he do? He escalated. A child herself. And he shows the other side of this defendant with those words. And y'all have heard enough of it. We're all tired. But the thing is, when you're thinking about how tired you are of all that language and all that, as they said, filth, what we say is his other life, this other side, this other dark side. Hey, those are his words. That's what's in his mind. That is the other Justin Ross Harris. And we know that he was leading this double life because he told people numerous times, I lead a double life. And in that double life, 2 weeks before this child's death, one of these girls he's messaging with asks him, after he's sexting with her, talking all like this, she asks him, after he's bragging about, well, I'm also the lead guitarist in a church band. Does your conscience ever kick in? And what does that defendant say? Nope. And we know for a fact that he showed that lack of conscience on June 18, 2014. He showed exactly who he is. We know he stated that in the weeks leading up to this, his breaking point was pretty low. We know that as June approached, his breaking point was pretty low. And we know that another young girl, well, he professed love for several of these young girls, many of them not knowing about the other, thinking they're the only one, leading all these different lives. The one that he was most emotionally attached to was slipping through his fingers. Janie Meadows. We know this woman that he had professed love to, who he told that if it wasn't for Cooper, that he would leave Leanna, was gradually cutting him off. And in those days leading up to June 18th, we know that on the 17th, the day before, he tried to message her. And she didn't respond. And he said, that makes me sad. And on the morning of June 18th, a couple of hours before he killed his son, he tried one last time to message this girl he was obviously in love with no response. And legally, unlike a lot of cases, in this case, we know what was in the defendant's mind that morning. Legally, you're going to hear that motive does not have to be proven in a criminal case. Now, we know that people commit horrible acts against children for no good reason. Unfortunately, it's just a fact of the world we live in. But in this case, he saw this host that morning. I hate being married with kids. The novelty has worn off, and I have nothing to show for it. Now they're going to say, oh, we saw a lot of posts. But think about it. When you know the timing in this case, within that 45 minutes of all the whisper posts in all the world, what did he seek out for not only you, but respond to commiserate with, while he is on the way to Chick-fil-A and while he's sitting there with this son, who to everybody else he portrays, I love him, I'm a great father, things like that. Which one side of him? He probably did. But guess what? That took a back seat. Because he responded and showed us exactly what his intent was and what was in his mind. He told this person he couldn't live his other life the way he wanted. His wife complained about him going out. He wanted to go out all the time, go out with other people. And most importantly, 10 minutes before he killed Cooper, he actually said that he needed an escape. But ladies and gentlemen, with all this evidence that we've heard, I mean, it's been days and days and days and days. It's like Groundhog Day. You know, come in, y'all know you're going to hear a bunch of filthy stuff. We know we're going to hear gruesome facts. We're going to hear stuff that nobody should have to hear. But what it all comes down to in this case can be summed up by a couple of the defendant's own witnesses. It can be summed up by the people they put on the stand to support their theory. We heard last week from Dr. Brewer, and he told us on cross-examination how the facts in this case, either some of the ones that the defense actually allowed him to know, and also some of the other facts that they kept from him. We learned how the facts in this case completely differed from other cases of a failure of memory systems. Right there, point blank, this case doesn't fit. And he told us, if this child was visible, flat out, if this child was visible in that car, that is not a failure of memory systems, flat out. This is not some forgetting. If that child's visible, you're not going to forget the child. And in this case, this child was visible 3 different times. When he got into the car in Chick-fil-A and drove, making turns in traffic, going into the parking lot, backing up, pulling in, being in there 30 seconds with that child, getting his bag that's to his right, getting his Chick-fil-A cup that he just had breakfast with his son, the drink he got. At lunch, when he goes back to the car. And in the evening, when he got in the car and drove away. As much as they tried, the defense cannot get away from the fact that has always been apparent in this case. Cooper would have been visible to anyone inside of that car. Flat out. Number of witnesses who testified had ridden in that car. Not a one came in here and told you that Cooper was not visible from the front of that car. Not a single one from the state or from the defense. And if there was, you're darn sure that question would have been asked. But they couldn't, because none of the witnesses could say that, because it's not the truth. If Cooper was visible from the front seat of that car, without all of this other stuff, the defendant is guilty of all counts. Now, also, while the state doesn't have to prove motive or prove that evil lurks in the hearts of some men, that humans sometimes take advantage of the vulnerable and the innocent and people they're supposed to love, we don't have to prove that. We know it happens. In this case, we know why he chose this method. He was an expert in it by June 18. He knew more about leaving a child in the car than any other human on the face of the earth by that day. Emails, warnings, watching the video 5 days before, instructing him basically, this is what can happen. He chose this method as well because he knew that he could get attention as an advocate. It was the only manner in which he could escape his son and in some sick, selfish, perverted, as his friends called him, grandiose manner, also become an advocate and get attention in that manner. And don't take my word for it. Take his own words. In the minutes and hours after he pulled his child out of that car, saying that he wanted to be an advocate, saying that another person has happened to them just like me, and they're an advocate. This defendant thought he was going to get away with this manner of murder because he thought he was smarter than everybody else, and he didn't think anybody was going to call his bluff. And getting back to that other thing that we learned from the defense witnesses. His own brother, Michael Bajan, told us that while we may not want to believe, and this is something in a case like this, it's hard to wrap your mind around the fact that somebody could be capable of doing something like this, even though we know in the world this happens. But we know it. And the defendant's own brother told us that sometimes the victim is someone who the defendant actually loves. But the offender kills them anyway. He told us that a parent someone who cares for a child and loves that child in one regard, oftentimes they're the ones who ends up killing or abusing them. And many times over, oftentimes it's the last person that you would expect who would do evil to a child. Outwardly great people who appear to love and care for kids who do the worst to children. Now, ladies and gentlemen, I am going to talk to you a bit now. The law has, basically, the state has a burden of proof. I know you aren't going to be thrilled about this. You get to hear from me twice. Yeah, everybody clap. Woo. No, we're not going to get that, are we? So I'm not going to talk as long the first time as I am in the second portion. What I'm going to do now is kind of go over some of the facts as they interrelate to the law the judge is going to instruct you on. Because I know we talked a lot in jury selection. What have you had any legal interests? You watch legal TV shows? Have you heard these terms? Beyond a reasonable doubt, shadow of doubt, things like that. Well, this is the point where, even in opening, when we were talking about some of these charges, you're probably thinking like, well, how does that apply to this fact situation or something like that? Well, now we get to the point where we actually get to talk about how the law applies to the acts in this case. So, first of all, as I told you before, when we're looking at the evidence in this case, we're going to be interrelating and talking about the facts as they apply. First, as we talked in opening, is a case about death, deception, and a double life. The torturous murder of Cooper Harris, the deception all over his life, and in this case with the police, his wife, and everyone involved, and the double life that reveals his motive and the malice in this case. Now that you've heard all the evidence, there is no doubt Cooper was burned to death in that car. There is no doubt the defendant lived a double life and was obsessed with his bad side. There is no doubt the defendant left Cooper in that car, and in this case, contrary to what the defense told you in their opening, responsible is guilty. Now, they came up here in opening and want to say, he's responsible, he's responsible. What do we get from the witnesses they put up? What do we get from the excuses they gave? They blamed everybody. Okay, well, yeah, he's responsible for that. Little Apron Academy should have called, even though the defendant knows they do not call if you miss a day. Leanna came up, and you heard her. That woman had been putting up with his mess for years and was still taking the blame for it. I should have done this, I should have done that. He even had his friend Billy come in and try to take the blame for his actions. Guilty is responsible in this case. Responsible is guilty. And there's no doubt the defendant is guilty of all charges. Now, let's talk about the law a little bit. First of all, okay, who here has heard the term beyond a reasonable doubt? Okay, we've all heard it. What does it actually mean? Well, the key word here is reasonable. It's not beyond some possible doubt. It's not beyond some mathematical certainty. It's a reasonable doubt. It's that of a fair-minded, impartial juror honestly seeking the truth. When you sit there as a juror, you don't run around looking under a rock for doubt. In this case, the truth smacks you right in the face. In this case, your job as a juror is to search for the truth. And as much as we may not want to believe that people are capable of this type of evil, that's exactly what the facts show. Now, what does it not mean? Beyond a reasonable doubt does not mean to beyond all doubt or some mathematical certainty. We have to have common sense and reason, ladies and gentlemen. Could aliens have come down and done something in this case? Well, I guess anything's possible. Is that reasonable? Absolutely not. The defense's theory. Oh, well, maybe it was a failure of memory systems. Well, when you look at all the facts, as Dr. Brewer said when we were showing him, did that lessen the likelihood of a failure of memory systems? Did this? Did that? Have you ever seen this in this case? Boom, 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 boom. That makes that not reasonable. And most importantly, I know y'all probably heard this saying before, you don't check your common sense at the door. When you go back in that jury room, you don't say, you know what, I'm going to forget all the common sense I have in the world, and I'm just going to throw it out the door and, not use logic. No, if you use your good common sense, if you use your good common sense in this case, the defendant is guilty of all counts every day and twice on Sunday. Now, evidence. Again, this is another thing I want to make sure y'all are clear on. We hear about circumstantial evidence, direct evidence. One thing to get clear while we start here. Direct evidence and circumstantial evidence are equal. One's not better than the other. They're just different ways of proving something has happened. Proving a fact. Proving a defendant's guilt. It can be direct or it can be circumstantial. Now in this case, we've got evidence of both. Let's talk about, first we've got direct evidence, which is something that points immediately to the question at issue. Then we've got circumstantial evidence, which is a fact proven by inference. Basically, an example I can give. I don't have my car down here. I've been having to bum rides off of all my coworkers since I've been down here. I left my car at home because I came down early and for a myriad of reasons I didn't bring it. But what I drive, you want to guess what kind of car I drive? Not a Mercedes, not a BMW. One of the worst life decisions I've ever made, I bought a Nissan Versa in 2009. Some of y'all probably don't even know what that is. It's like a little car that you think would get good gas mileage and be eco-friendly. It's not even the one that gets like electric or anything. But anyway, one of the good things about it is it does get decent gas mileage, but eventually, or on occasion, I got to go put gas in my car. Now I go to the gas tank, I pull in, I get out, pop open the gas tank, swipe my credit card, get the hose off, put it in the car. Click it. You can hear the gas start running through the hose. You see the money, unfortunately, going up and up and up and up and up. Okay, oh God, how long is it going to take to fill it up? Again, it's a small tank, so not that much. But anyway, it clicks, put the hook up, get in my car, turn it on, and it's full. Maybe I was on fumes when I came in, but the tank is full. And I drive off. Now, did I actually personally witness the gas getting into that car? Absolutely not. But circumstantially, we know it happened. That is proof by an inference. Now, let's look at these different types of evidence in this case. First, direct evidence. We have a ton of direct evidence and circumstantial evidence in this case. I mean, I'm sorry for y'all. You're going to have a little over 1,000 exhibits back there to go through. Some of them y'all are probably like, all right, great, we finally get to look at this. Others you're going to be like, I don't want to look at that. So, but you're going to have a lot to go through, and there's going to be a lot of both types of evidence. First, direct evidence, the video evidence in this case. There's no doubt the defendant left Chick-fil-A at a certain time. There's no doubt he parked the car the way he did, and he left the child in that car. There's no doubt he went back into the car at lunch. There's no doubt he went back in the car and sped off that afternoon with the windows up within 3 seconds of the door closing. All kinds of video evidence in this case that is direct. You have photographs that are going to be direct evidence in this case of the child on the scene, of the scene. Lots of photographs in this case of the car seat in that car as it appeared on June 18, 2014. Direct evidence of the defendant's own statements to the police and his wife. Remember some of those comments he made to his wife? I was dreading how he was going to look. I wouldn't bring him back even if I could. Hours after he's pulled his son out of the car. The direct evidence of him telling y'all he wanted an escape 10 minutes before he got his wish. Now, circumstantial evidence, what do we have? And there's a ton of it in this case, and I'm not going to go through every little bit of it, because what it comes down to, ladies and gentlemen, y'all's collective knowledge and memory of the facts and evidence in this case, y'all sitting together going over it, is going to be much better than just me sitting up here telling you what happened, or the defense attorney sitting here telling you what's happened. That's why we have you guys here in this case. But I'm going to go over some of the stuff just so to recap, because we've been going for several weeks now. Circumstantial evidence. Not just the video that he returned to the car at lunch, but the fact that he returned to the car at all. And we'll talk in more detail about that later, about what that means and what it didn't mean. Motive evidence in this case. Motive evidence showing this person's double life and what his priority was in the days leading up to and especially on June 18, 2014. Circumstantial evidence of the defendant's own expert witness. He gave us circumstantial evidence of this defendant's guilt. All these facts leading up to it, well, that's not going to make it likely that he forgot. That's not going to make it likely he forgot. You know what? If this was intentional, like the defendant said it was going to be, my testimony has nothing to do with this case. All these other things as well. The defendant's departure from work, the route he took, which from everybody, unrebutted, was not the right route to take to the movie theater. The route you would have taken was much less traveled. There weren't a lot of businesses. There was no crowd out there. The smell in that car. Circumstantial evidence. Again, video evidence, text messages, the lies in his timeline about lunch, about his relationships with Leanna, and about what he was doing that day at Chick-fil-A and after. He wasn't truthful with the police about what he was doing. And demeanor. Everybody, to a person, says that his behavior was inconsistent. You have seen and heard the videos. Now, in opening statement, the defendant showed you a couple of small clips. Now you've seen the full videos. And I'm sure once you saw it in there and you saw Officer Piper's video from the jump, you're like, wait a second. That's not how it was portrayed to me. Y'all saw that. Y'all saw his demeanor. And you see his demeanor there in the interview room where he's huffing and puffing. You don't see him wiping any tears, snotting a rag in a shirt, anything like that. You see him doing exactly as it was described at the scene, as Detective Piper said, like Will Ferrell, yelling a lot, and then he's calm and looking around. And that's what we saw in that interview room. It wasn't until, and this is evidence of demeanor, until after he was arrested, after he was detained and told he was going to be arrested for these charges, did we see him get that real emotion. I'm not going to sit here and say he wasn't emotional in that room with Leanna. Because he was. He was sobbing like a baby, talking about, I felt bad about it. Why me? They got a metal toilet and a cot that's uncomfortable. Asking Leanna to make sure he didn't get arrested. Demeanor. Okay, you're also going to be instructed on the law of intent. Now, intent. What is intent not? It's not an intent to violate the law or commit a crime, a specific crime. The defendant did not have to wake up that morning and be like, you know what, I'm going to violate Code section OCGA 1651, and I have an intent, I'm going to commit all of these elements. No, that's not what intent is. Intent is basically what is shown in the different counts of the indictment. Did he have that specific intent at the time he committed the acts? For example, we'll talk about this a little more in a minute. Counts 2, 3, 4, and 5. There is no element, and you do not need to prove that there was any intent to kill. While we have it, those elements are not required for those specific counts. In fact, in counts 3 and 5, you're going to see that you only need criminal negligence. So when we're talking about intent, it's specific to the charge in each count of the indictment. Okay. You're also going to be instructed that intent can be inferred from the proven circumstances or by the acts when it's the natural and necessary consequence of the act. And then there are several things you consider when you determine the intent. Words. Conduct. Saying he loves his family and doing all the things he was doing. I think actions speak louder than words, ladies and gentlemen. Demeanor. And the defense is going to get up here and tell you, you disregard demeanor. People react different ways. Well, yeah, people react different ways. but not in the way he did, A. B, the law actually says you consider demeanor. When they tell you you don't, the law says you do consider it when you're looking at somebody's intent. Also, you look at motive and circumstances connected with the act. All of those factors in this case prove the defendant guilty of all counts. Now, the judge is also going to tell you, and this is one thing that, you're probably thinking different things in your head before you got in here. What's premeditation? Motive? What do all these things mean? First thing you're going to hear on this issue about motive. Motive is not an element of any crime. It's immaterial to the charges in the indictment. Unfortunately, sometimes you never know why somebody does an evil act and commits an evil act. So, basically, we could have shown no motive evidence, but shown, like he did, that that car seat was visible, and he left that child in that car. He's guilty. But we have an abundance of motive evidence in this case. Okay, expert testimony. The judge is going to instruct you on expert testimony. We heard from several experts in this case. First of all, they can come in here and give you opinions based upon their training and experience. Not just academics, but their actual experience, either in law enforcement or as a medical examiner or as a memory expert. However, the testimony of an expert is to be taken like that of any other witness. You are to give the testimony of any expert witness the credibility which you think it deserves, the weight which you think it deserves. For example, Dr. Brewer gave you some expert testimony. One, if this was intentional, his testimony is absolutely meaningless. He told you he's never seen circumstances like this in a case with a failure of memory systems. In fact, his testimony ended up supporting the state's case. And the defense kept him in the dark on some of these facts, didn't give him all the information. And you saw what happened when he was confronted with this information. He had to make admissions. This was the horse, this was the wagon that they hitched their horse to. And even you can discredit some of the end of his testimony when he was asked, and y'all saw this, and I think everybody was exasperated in here at that point. So, you would agree that if this person is fatigued, and it's because he is doing all this stuff instead of working, and he has made himself tired, and he's fatigued because he's doing everything but take care of his kid, doing everything but being responsible, that makes him responsible. Well, no. He knew he couldn't say yes to that, because it would have sunk the defense completely, but we all saw it. All right. Punishment. We talked about this in jury selection. We don't really need to go into it, but punishment, if anybody, you can't consider the issue. It's not an issue if there is any punishment in the case for a jury. I know y'all been here, y'all been following the instructions marvelously. This has been a pretty exceptional case as far as having to follow certain directions you may not obviously or always have to, things like that. One thing is, obviously you can't consider this. If anybody in the jury room starts talking about this issue or anything, you need to send us a note because that wouldn't be following your oath. But I know y'all have done everything outstanding in this case, so that's not going to be an issue. Just letting you know, that's the law. Venue. It's not going to be an issue in this case. While we're in Glenn County, this case happened in Cobb. What we have to prove venue is where an injury happens or where the child dies in a case like this where there's a child or where the body of the person is found. In this case, there's no doubt. Every act and everything involved in this case, you've heard the testimony that it all happened in Cobb County. So there's no doubt the venue has been proven in this case. Okay. Same subpoena powers of state. Now you're going to hear the burden of proof and the presumption of innocence. The defense is always presumed innocent when they come in this courtroom. And that's one of the great things about this country. Everybody comes in here with that presumption until the state removes that presumption with evidence. It's a great country because we have that. But in this case, it has been removed. Because also, it's a great country where some other countries They put up with child abuse. They don't care about it. We have laws to protect children. Now, in proving that, and with that presumption of innocence, the defense could sit there, they don't have to put up evidence, they don't have to put up witnesses, they could play dominoes over there if they wanted. However, when they choose to make an argument, or when they choose to ask certain questions, or when they choose to put on witnesses and things like that, they have the same subpoena power as the state. To bring in any witness they want. To bring in any evidence that they have that they want. So just know that. They have absolutely that same ability when they're up here arguing about something.
Judge, I'm going to object. I'm going to object that this is a burden shifting argument. This isn't proper.
Judge, the law's been cleared for about 30 years on this.
Go ahead and argue.
Thank you.
But ladies and gentlemen of the jury, I'll instruct you on burdens, and that's what you should follow. Go ahead.
Thank you, Judge. So as I said, they have the same subpoena power as the state. Now, let's talk about the charges. What we're going to start with here, we're going to go from the bottom of the indictment up, as far as the bottom charges starting with counts 6, 7, and 8, and then go up as we talk about different levels of intent, different levels of proof in this case. So let's start here. First of all, we're going to talk about counts 6, 7, and 8 as a group. Then we're going to talk about counts 3 and 5 together. Then we're going to talk about counts 2 and 4. And finally, count 1. So let's start. Count 6 on 6, 7, and 8. This is going to be criminal attempt to commit the crime of sexual exploitation of a minor. And these crimes, when we're talking about minors, pursuant to this count and count 7 and 8, it means somebody less than 18 years old. A child less than 18 years of age. So, to prove criminal attempt of a crime, what we have to prove is that the defendant took a substantial step toward the commission of the crime. The crime in this case would be sexual exploitation of a minor. What we have to prove is that he took a substantial step to persuade, entice, ask for a person under 18 years of age to send a lewd picture. In this case, under the law, it would be a lewd exhibition of the child's genitals. That is sexual exploitation of a minor. Also, that can be committed not only by trying to get somebody to send that to you, but it's a completed crime if you possess that type of photo. If somebody sends you a picture, either the minor themselves or another person, if it's a photograph or image of somebody under 18, then that's a violation of the statute. So, did he commit a substantial step toward that crime? Specific instances, well, first of all, this is not a completed crime. If that photograph had actually been sent from the victim CD in this case, who testified to you, who was 16 to 17 years old at the time, if she had sent that photograph to him and he possessed it, it would actually be the completed crime. But what we have is him trying to get that. Here, there's no doubt, unrebutted, she was 16 and 17 years of age at the time, a junior in high school with this married 30-something-year-old with a child messaging her. This was an attempt, and you'll see with the date range in the indictment, that was ongoing. It was actually going on longer than in the indictment. I think the first request you're going to see from those chats was back in 2013. Repeatedly, over and over and over again, at least 6 requests for the defendant to send, for the victim to send the defendant a picture of the child's genital area, vaginal area. There's no doubt about it. It's here in black and white in the chat. No doubt. And he did it again and again and again. Also, just in case, even if he thought that while he could statutory rape, you got to be under 16, things like that, that wasn't the crime he's being charged with. And ignorance of the crime is not a defense, just so you know that as well. And the defense isn't going to argue that, because they know that full well. Now, so there's no question whatsoever. The defendant, just in that one notebook, is guilty of count 6. He's obviously going to be guilty of counts 7 and 8 now as well. First, dissemination of harmful materials, and this count is charged one way. In count 8, it's charged a different way. First, you send to a person under 18 years of age printed matter, in this case that can be typed form via phone, via computer, things like that, explicit and detailed verbal descriptions and narrative accounts of sexual excitement and sexual conduct. And it taken as a whole is harmful to minors. The chats in this case showed that this defendant was coaching a 16-year-old on how to perform oral sex, sending photos and foul descriptions of sexual acts. And the difference in this, and why this is a crime, he's an adult. He's an adult, 33-year-old male, and it is harmful. Who knows the lasting psychological issues years down the road when you've got a child thinking about the bad decisions she made when she was listening to an adult. An adult that she admitted she was in love with. And a defendant, if y'all remember, who told her that he wasn't going to follow through initially with her as far as having actual sex or anything because he knew she was innocent. Y'all remember she said that. He knew I was innocent, he knew I was vulnerable, but he still used her for his own sexual obsession. Count 8. Again, the same crime charged in a different manner. And you're going to have in some of these counts like this, there are different manners in which a crime can be committed. It's called charging in the conjunctive. Now you're like, what the heck does that mean? A lot of times, lawyers, I don't know why we make up stupid rules sometimes, but we do as far as semantics and double talk. It seems like and means or. Basically, if you've got an indictment where it says he basically sent, like in this count, a photo-visual image depicting sexually explicit nudity that was a male in a state of undress exposing his genitals and a male genitals in a turgid state, we don't have to prove both of those different ways. All we have to prove is one of them. When it says and, it means or. You have to prove that he sent this or he sent that. And ladies and gentlemen, it really doesn't make that big a difference anyway, because he did both in this case. Obviously, y'all saw the photographs. We entered them. There's no doubt about any of those elements. I'm not going to belabor it. And there's no doubt this, as taken, is harmful to minors. All right. Now, let's go to counts 3 and 5. Counts 3 and 5. Felony murder based upon cruelty to children in the second degree. Now, what do we have and what are the elements of these two crimes as we talked about them in the indictment? And based simply upon what the defendant told the police and what he said and his actions throughout that day, leading up to it and after it, just based on that, he is guilty, no doubt, to counts 3 and 5. Now, this is based on criminal negligence. Now, what does this mean? How does this work together? The underlying felony and felony murder. Felony murder, as opposed to malice murder that we'll talk about later, does not require any intent to kill or specifically any type of malice, although that may be a component of one of the lesser charges. But in this counts, with count 3 and 5, it doesn't come into play. What we have is criminal negligence. Okay. First of all, for counts 3 and 5, there is no intent to kill element. There is no malice element. Basically, look at it kind of from the bottom up, starting with count 5. What do we have to prove? That Cooper was under 18 years of age. There's no doubt about that. There's cruel or excessive physical pain. We heard from the medical examiner. You've seen the photos. We even heard it from the video the defendant watched. There's no doubt about that, how this child suffered. With criminal negligence. And basically, to make a felony murder, all we have to show is that based upon those acts, the child died. That's it, cut and dry. Now, one thing I just want to point out, as you think about this, and as we get into counts 2, 4, and 1, the defense in their opening statement made a huge deal. And I think it was about 8 minutes in, and said that they want you to pay attention to something that is crucial to this case. That is basically a linchpin of their case. He told you wanted to listen, wants you to pay attention to this very closely, because it's very important when it comes to intent in this indictment. He told you the defendant was not sexting that day until after he dropped the bra. That's what they were hanging their hat on in their opening. They told you that that was a crucial part of their defense. And right out the gate, we know that's not the truth. That's not the evidence. That's not what happened. So, when we're looking at counts 3, 5, 2, 4, and 1, keep that in mind. This was crucial to their case, and the evidence was completely the opposite. This defendant, there was overwhelming and undeniable evidence of criminal negligence in this case. Before we even get to motive, just based on his statements alone and his actions that day. So, what is criminal negligence under the law? It's an act or a failure to act that demonstrates a wanton, willful, or reckless disregard for the safety of others who might reasonably be expected to be injured by that act or failure to act. Okay, safety of others who might be reasonably expected to be injured. Everybody knows that leaving a child in a car for 7 hours, that's a danger. That's reasonably going to be expected to injure. And as far as a reckless disregard, let's talk about that for a minute. Just looking at the defendant's own admissions. We're not even getting to all the evidence in the case. This defendant knew more than anyone in the world, it seems, about the dangers of this. He told the detectives as much. He'd seen an advocate on TV. Or actually, I don't even think in the interview he said it was a TV necessarily. He saw an advocate this happened to. He talked about a dog that this had happened to when he was in Alabama. 5 days before, he saw a video about the dangers of this. And even put his son in an animal's place. And said, I would hate for that to happen to my child. He got look-again emails, an email from his wife. They had talked about the dangers. Y'all remember those conversations? That was our worst fear. We talked about it a lot. The defendant knew he could take steps to prevent this, and didn't. He consciously disregarded these dangers. He actually told you in some of his statements to the police, oh, I guess I didn't do a second look. And then he said to the police station, oh, I guess I should have put my bag in the back. Not only, per the defense's explanation about how this could possibly happen, or if it was forgetting and you couldn't see the child in the car, that can happen if you can't see the child in the car, and there's maybe distraction or fatigue. The defendant sexting the night before, up late, up early after his son goes back to sleep, while at home, on the way to Chick-fil-A, at Chick-fil-A, and throughout the day, constantly with his obsession. All of that, unrebutted, is a starting point of counts 3 and 5, the defendant being guilty. But ladies and gentlemen, we don't just look at what he had to say. Luckily, we have an entire investigation and a ton of unrebutted evidence in this case that shows that this defendant's obsession was much more than some type of criminal negligence. It was an intentional murder. Okay, you're going to hear some charges relevant to possible defenses, if it were a defense in the case. First of all, accident. You're going to hear that for there to be somebody to call something an accident, it only applies if the person's not responsible at all, and you cannot apply accident if there is a criminal scheme, intention, or criminal negligence whatsoever. Accident in no way applies in this case, because even if you believe the defendant, it's criminal negligence. Accident, throw that out. This isn't an accident, because there is, at a minimum, criminal negligence, and the evidence shows there was criminal intent. Mistake of fact, that's not going to come into play either, because that says it's a mistake. If it is induced by the defendant's own fault or his own negligence, it is not a defense. Take mistake of fact, throw it aside, because legally you're going to hear it doesn't apply to this case based on these facts. All right. Counts 3 and 5, no doubt the defendant is guilty. Now, counts 2 and 4. Felony murder based on cruelty to children in the first degree. Let me talk a little bit about this. This, as charged, there is no requirement of an intent to kill, even on these counts. No requirement of an intent to kill. There is a malice element, but we're going to talk about that because malice as it applies to cruelty to children in the first degree is a little different than malice as it applies to malice murder we're going to talk about in count 1. So, starting again from the underlying felony cruelty to children in the first degree. We have to prove that Cooper was under 18 years of age, check. That he suffered cruel and excessive physical pain, check. And that the defendant maliciously caused this. And we're going to talk about it. What does that mean for this count? And then based upon that, for the felony murder that works with it, all we have to do is prove that as a result of this count, as a result of that act, the child died. So, looking at it, what does malice mean for counts 2 and 4? It can be one or the other, two things. It's not ill will or hatred. And we're going to talk a little bit about that more in a minute because y'all heard the defense ask several people about ill will or hatred. Playing word games because those aren't elements. First of all, not ill will or hatred. That's not what malice means in any count in the state of Georgia. For this count, it means either an intent to cause the particular harm, which is pain, leaving your child in the car, knowing he's sitting there, you know he's going to be caused pain, without justification or excuse, or the wanton and willful doing of an act with an awareness of a plain and strong likelihood that such harm may result. No intent to kill, but leaving that child in there knowing that what's going to happen to that child by doing it. And then the child dies. The defendant's guilty of counts 2 and 4. Now count 1, malice murder. Y'all probably are thinking, what does this mean? You've got a bunch of preconceived notions maybe coming in, things you've heard on TV. Let's talk about what it actually means. First of all, the judge is going to tell you the law is that it does not mean ill will or hatred. You heard the defense ask several witnesses, did he have any ill will or hatred toward his child? That's irrelevant. That's not an element in this case. And it's not in this case that wherever anybody has said that there's any evidence, other than the death in the end, or any evidence that the defendant hated his son. Ladies and gentlemen, this isn't a case about an adult hating a child. This case is just like it was with his wife and how he showed. It's just that he loved himself and his other obsession more than that little boy. That's all it is. It's not ill will or hatred. His own brother told him that people kill ones they love or espouse to love for their own selfish reasons. And oftentimes, it's the last person you would expect. Malice aforethought caused Cooper's death by leaving him alone in a hot car. Not ill will or hatred. What it is, for this count, malice, it's a killing without justification, excuse, or mitigation. This case is the epitome. Killing a young child, there is no excuse for it. No justification. No mitigation. The fact that he was a good dad on some other occasions does not excuse or mitigate taking a life for your own selfish reasons. Now, malice, as it's defined, it can be either express or implied. And we have both of those in this case. Now, what does express malice mean? What does implied malice mean? Express malice is the deliberate intention to take a life. The deliberate intention to take a life, which is shown by external circumstances capable of proof. In this case, the express malice, the hours that child spent in that car, the helplessness of this young victim, the defendant himself expressing 10 minutes before that he needed an escape. Implied malice. Now, what is that? It's when no considerable provocation appears and when all of the circumstances of the killing show an abandoned and malignant heart. This killer's heart abandoned this child long before he died. This defendant's heart abandoned this child when he left him to die a terrible death in that car, when he came back to check the scene at lunch, maybe even to make a discovery in front of his friends there until they pulled off too quickly. Quite possibly discovering, as we've heard from the evidence, that Cooper could have been alive in that car. And abandoning him yet again. And sat there malignantly while that child cooked in that car. That, ladies and gentlemen, in this case, is the epitome of an abandoned and malignant heart. Premeditation. I know a lot of people talk about premeditation. Is there premeditation? Remember this at all times. There is no premeditation at all. We don't have to prove that he woke up that morning and at 7:55 decided, you know what, I'm going to murder my child. Unfortunately, most cases like this are a crime of opportunity. When it presents itself, when your mind gets in that point, you do it. Now, one thing, I've never been able to whistle very well. My wife gets mad at me when I try to whistle, and that's terrible. I can't do it. Another thing I can't do is snap. A lot of people give examples of how quick malice can be formed. And they snap, because it's that quick. Malice can be formed in an instant, and the judge is going to tell you that. As soon as the defendant decided and formed that in his mind and said, you know what, I'm shutting the door on this child, that's malice. There's no premeditation required. Although the evidence screams that he'd been thinking about this for quite some time. We talked about no motive being required. We talked about it being formed in an instant. What is the malice in this case? .6 miles. The distance the defendant drove from Chick-fil-A to that parking lot. 0.6 miles. 4 minutes. 4 minutes. Around that time, about the time it took the defendant to get from Chick-fil-A, the first time he's seen pulling in that parking lot. 4 minutes had also included the time that he would have gone out to distract his child into the car, where he talked to his child, where the child was awake while he strapped the child in. It's much less than 4 minutes, but that's malice in this case, that amount of time. 30 to 40 seconds, the amount of time it took for him to pull out of Chick-fil-A and turn around at that U-turn and make that decision to not take him to school. 30 seconds. The malice shown, the time that he spent in that car after he had pulled through, backed up, and parked that car, with that child sitting right there, visible to anybody in that car. 3 seconds. The amount of time it took him to close the door in his car, windows up, and drive off at the end of the day. Because he knew he had a dead child sitting there beside him. 1 return to the car. 1 return to the car that he lied about. And the defense is going to say, well, Winston forgot too. Well, keep in mind, Winston told you, well, he wasn't going to get light bulbs. He was distracted by his phone. Keep in mind, this was not Winston's car. This was the defendant's car. This was the defendant's child. This was the defendant who opened up the door and got in the frame. This is the defendant who threw light bulbs. Threw light bulbs. And we'll talk more about that later. Why would he try to avert his head? Why would he throw light bulbs instead of sitting them down in the back seat or taking them into the building? Because he knew what was there. He opened up that door. Whether he was alive or dead, he knew exactly what was there. And malice is shown in his two lives in this case. And his desire to escape from one of them to leave the other. And it also comes down to, you know, we're going to have all of these pictures back there, and we'll look at them a little bit later too. A matter of inches. The distance from where little Cooper's head was. And that defendant sitting right there in that car. The defendant is guilty of malice murder in count 1. In this case, as I said, there's no doubt about all of these things in the defendant's guilt of all charges. But a few questions. The defense counsel is going to get up here, and he's going to make his argument to you as well. And I just want you to keep a few things in mind, both while the defense is making their arguments, when I get back up to talk to you about the facts, and when you're back in the deliberation room. First of all, since this was the crux, or very important to the defense in their opening, think about this through the entirety of your involvement in the rest of this case. Was the defendant actually sexting before he got to the Home Depot on June 18, 2014? If so, that blows the defense's argument out of the water from opening. Did the defendant, in fact, lead a double life? We can talk semantics and argue all we want, and witnesses may not want to answer it the way we ask it. But come on, be for real. Did the defendant live a double life? Also, how many things did Dr. Brewer agree lessen the likelihood of a failure in memory systems? How many things? How many things did he say? A case that he initially said was not unique, and then could not give one similarity about in any other case. Finally, is that how the crime scene looked? On June 18, 2014? Is that photo accurate? Car seat that the defendant put him in at Chick-fil-A? Kissed him? Navigated changing lanes on the way to that parking lot? Is that the car seat? And how it looked when he passed the parking spot on the right? And as the defense tried to say, oh, that's some choice parking lot. Sorry, I'm kind of train of thought. It came to mind then. You remember how they tried to do that with that one witness? Oh, this is some special parking lot. The video you saw, all the other parking spots were full. That one was left open that day. So come on. But in any event, is this the same parking seat, the same car seat, as when he backed up? Backed up like this and pulled straight. Is that the same car seat that was in there? And how it looked when he was in there for 30 seconds on June 18, 2014? Is that how the car seat looked when that child left Chick-fil-A wide awake, being excited for school? Is that the same car seat that the defendant had to reach by to pick up his work bag to go into work that morning, that we saw him walk in, that he admitted he got from his passenger seat? Is that the same car seat that he got back into that afternoon and within 3 seconds fed off and drove for some time with that child there, having been baking all day in that car, making those turns all the way there on a route that he shouldn't have taken? Ladies and gentlemen, it all comes back to this. That's how that car seat looked on June 18th. defendants guilty of all counts. Thank you.
Ladies and gentlemen, close your notepads and retire to your jury room for a short break. Open mind, no conversation. Have a good break.
Let's all rise and be heard, please. Please watch yourself when we go. Watch yourself when we go.
Bill. Let's be in recess. Let me know when you're ready, Mr. Constable.